Hello everyone, and welcome to Legal Ease with RLC Advocates, where we simplify the law, unpack legal issues shaping our society, and make legal conversations practical, insightful, and accessible. I am your host, Esiline Okasida, and today we are discussing a topic that affects almost every workplace in Kenya. Common employment law mistakes every employer makes under the Employment Act. From unfair termination processes to redundancy disputes, workplace policies, and compliance obligations, employment law continues to evolve rapidly in Kenya, and many employers are struggling to keep up. Joining me today is the brilliant Maryanne Njogu, advocate of the High Court of Kenya. Maryanne, thank you so much for joining us.
Thank you, Esiline, for inviting me. I'm happy to be at Legal Ease to discuss issues that are very close to my practice.
Karibu sana. So, Maryanne, let's just go right into it. Many employers believe that once they have a valid reason to dismiss an employee, then that's it. Legally speaking, does that actually count? Is that the position?
Well, employers have a right to terminate, but just having a valid reason is not enough. Mm-hmm. How the employment law is actually set up is that not only do you have to have a valid reason, and by valid means you need to prove it's valid,
yes,
right?
Yes.
And then underlying that valid reason, every valid reason has its scope of requirements. If your valid reason is disciplinary, it has scope of requirements. If your valid reason is performance, it has scope of requirements. Have you met those scope of requirements? Then the final thing is procedure. Every valid reason under its scope of requirements has a different procedure to be followed.
Oh, wow.
So if you haven't followed the procedure, then it all comes falling down, and the employers then end up in trouble with the law. Yeah, so just a valid reason is not enough.
Wow, that is very insightful. And why does procedure matter?
How the law, of course, is structured, we all agree that employer-employee relationship is imbalanced. And of course, the employer has a bigger ego. That's your boss, the person paying you, and the person making the decisions.
Yes.
So the employment law, how it is and how it's interpreted, favors or protects an employee from arbitrary actions from an employer who's considered to be at a more advantageous position over an employee. And that's why procedure is important.
So, for example, say I am an employer, right? I have employed several people under me, and I decide to dismiss someone because of poor performance without even putting them under
performance
review procedures. Without putting them under performance review procedure, or because maybe the business is struggling and I haven't even given them a valid reason. I've just said, hey, I am terminating you. Here's your 1 month's pay and here's your notice pay. Please go away.
Many circumstances, of course, there are a few assumptions that are there in the market and how employers operate. You assume, like what you've just said, just because I've paid you your month's salary and paid you maybe notice pay because I haven't given you notice, then I'm good to go. No, like you said, if your reason to terminate is performance, let's start with performance. What the law is and what courts have said is when your reason is performance, you need to show us KPIs, the key performance indicators. Because when you're telling an employee you've performed poorly, it's against which background. Okay. So even before the poor performance, the workplace has to have a structure of employment, of performance goals. What are the key indications of performance? That has to be laid out, communicated to the employee. And if an employee is having performance issues, the first thing you need to do before termination is actually do a performance review. And that is usually provided for in many contracts. And upon the performance review, if the performance is below standard, then what do? You have to try and put the employee in a performance improvement plan.
Yes. Yes.
Right? And this is the issue. This is where we want to improve. Give them all the tools they need. Does that employee particularly need training? Is it an issue of training gap in that area? Give them the training that they need. Give them the tools that they need. Then importantly, give them enough time to try and improve. Some of the mistakes I have seen people do in performance is we've had a performance review, your performance is low, we've communicated that to you. Yes. In less than a week, you now have a notice terminating your poor performance.
Yes.
Then when we go to court, the court argues that you didn't give the employee enough time to actually try and improve their performance. So you need to have key performance indicators that are well communicated to your employees. When there's a performance issue, put them under a PIP, which is a performance improvement plan, and then give them time to improve. When it then fails is when you can do now the procedure. What I was explaining is what we said, every reason has its own attributes that you must have. Then you will follow the procedure to terminate.
So what's the procedure?
So in that case, you have given them, you've put them on the PIP, they've not improved, then now you can issue a notice.
Okay.
Right? Based on performance evaluation already communicated to you, the performance improvement plan, and another evaluation, your performance has been found not to improve. And then again, remember, notice is contracts determine notice. There's what is minimum under the law, under the Employment Act, and then most contracts provide for 1 month notice. And of course, the other thing we need to correct is, as an employer with contracts, you're allowed to put the terms that you want, but make sure these terms are better, are either the same as what is provided in the Act or better than what is provided in the Act. You're not allowed to give less than what is in the law. So make sure your notice is at least 2 weeks to a month. So you give your notice explaining your reasons, and then now at the end of the notice is when you give you tabulate the employees' dues.
The final dues.
Yes, do they have leave accrued days that you need to pay? Is it an employee who needs severance pay? Is it an employee who needs service pay? Because there are certain employees that need service pay. There is also gratuity pay. You need to think about that. How long has this employee served you? Do you think they deserve a gratuity pay? Consider that. And then now these dues are also communicated in that notice. Then now the employee has proper notice, you've taken them through the performance review. It can now be traced back to how you ended up terminating the employee based on performance. If it's an issue, for example, of disciplinary. Let's now come to disciplinary. That's a different reason. Then if it's an issue of probable misconduct that requires a disciplinary, the first thing you need to do is, for example, issue a show cause. I probably didn't report to work, I didn't give valid reason. The first step is to issue a show cause.
Before you go any further, how long, for example, if I have missed work, how long does it take before my employer issues a notice to show cause? Like, does me being absent from work for 1 day or 2 days give my employer the right to, give me a notice to show cause?
That's a good question. And I'll answer it in 2 ways. Sometimes yes, but there's a procedure that employers are recently and mostly missing. Taking advantage of warning letters. There's a reason why warning letters are provided as practice in employment law. When a mistake happens for the first time, it is upon you to issue a warning letter. The first warning letter that, this happened, here is your warning, let it not repeat itself. And actually good practice requires you to issue at least 1 to 2 written warning letters. Another mistake that employers do, which goes into records, and maybe we'll discuss records a bit later. But just to mention is you give verbal warnings, and then it's not written down, it's not recorded, it's not captured. That is of no use in court when you have been sued for unfair termination.
Because
so let's take advantage
of
use a warning letter, issue the warning letter. If the employee repeats the mistake, perhaps issue a second one, but that then goes back into the operations of the company. If you're not able to issue a second warning letter, that's when you now issue a show cause letter. And the other thing that people do is you issue a show cause letter, which requires you to respond. But give an employee very short time to respond. Just because the employee missed work or did something that you could consider misconduct does not mean they don't need time to think through and explain. So issue a show cause, give them sufficient time to respond. And if the response is not sufficient to an extent that you feel you need to do a disciplinary, remember, not every show cause must lead to a disciplinary.
True.
I could respond to your show cause and my reasons are valid for you to consider. It is when these reasons are not valid and cannot be tolerated by the company that you proceed with a disciplinary hearing. Now, disciplinary hearing is a whole issue on itself. How you conduct the disciplinary hearing. So now you give a notice to invite the employee for a disciplinary hearing. And in that notice, there are basic minimums that need to be there. You need to inform them that you're inviting them for a disciplinary and why. What is the accusation against the employee?
Yes.
You also need to inform them that they have a right to defend themselves and even bring evidence to support their reasons or their explanation.
Yes.
The other thing you need to inform employees, and many employers don't, is that you need to have a witness or a representative of your own choosing in the disciplinary meeting. Many employers leave that out, and that's very critical. And then now you also need to give them sufficient time between when you invite them for disciplinary and when they come to the disciplinary.
Yes.
Don't write a letter inviting someone to disciplinary, for example, today 21st, and the disciplinary is on 23rd, and you've asked them to gather evidence. You understand?
Yes.
And the reason why I'm bringing these things out, someone might think, okay, why is this important? The court does not just look into procedural justice.
Yes.
They look for something we call substantive justice.
Yes.
Did you just follow a process for the sake of following the process? Did you just issue a letter because the law says, or did you issue it in a way that we can say justice was actually being done and you're intentional with the process? Then when it comes to the day of the disciplinary, the employee has a person present, you tell them the charges against them, the issues, and then they get a chance to respond. The other thing people miss, even in performance meetings that we've talked about, is minutes. You've done a performance review, no minutes whatsoever of what was discussed. You've done a disciplinary, no minutes for whatever has been discussed. And employers really underestimate the importance of records when you've been sued in court. Because there I am trying to tell the court that you actually did the disciplinary hearing, and now you're being cross-examined on where are the minutes?
Where are the records?
Where is your proof? A court of law is a court of proof.
Yes.
Where is your proof that? And it's as simple as minutes and signed minutes, both by everyone who was present as well as the employee. So these are basic minimums. Basic minimums that every employer needs to meet.
Okay. Before you even go further, at the disciplinary hearing, does the employee need to be informed that they can either speak in English or a language that they can understand, like Swahili or their mother tongue, or is it strictly English?
No. Remember, this process as you do it is not just for you as the employer, it's mainly for the employee. And I started by saying you are considered as if you're in an imbalanced relationship.
Yes.
And therefore you should tilt the balance towards the employee. One thing you need to ask this employee, what language are you comfortable with? If they're comfortable to do Kiswahili, explain to them the charges in Kiswahili and allow them to explain themselves in Kiswahili. It's the same thing we do with court, even with witnesses. We have to confirm your witness actually wants to proceed in English or Swahili. And then extensively in court, we've had interpretations in mother tongue, right? So that's a requirement under the law because they cannot respond to something they don't understand.
Very true.
So make sure the language is reachable to the employee. And this is so much important, especially for casual employees. In many cases that we have dealt with where casual employees are involved, I have actually realized when reviewing the documents, even when you review the document where the casual employee responded to a show cause letter, even their way of writing is incoherent. They cannot properly write in English. You as a lawyer, you're struggling to read what they are trying to communicate. Then how then would they do a proceeding fully in English? So you need to understand the type of employee that you have and make sure that the setting is important for them. And especially even disciplinary or some kind of settings where an employee has been accused of something, or even an employee has complained of something, and then you have to do a meeting about it. When I've complained about a certain supervisor, maybe for harassment or whatever it is, bullying or those kind of things, and we are having a meeting where the supervisor is present, how well do you think this employee is going to communicate their concerns? And especially if they claim the supervisor is intimidating or bullying them.
They won't speak out.
Then that meeting is not productive. So those are the things you need to take into account. Let them explain to themselves in a way they can understand. Another important thing, read to them those minutes in a language they can understand. Let it be written in a language they can understand. So that when they are signing,
they know what they are saying.
They know what they're saying. One of the challenges we've been having is you go to court and the employee claims, this document that I signed, I actually didn't understand it. The minutes were not read out to me. I didn't know what they had written and I was actually coerced to sign it. And then you see it's their word versus
yours. Yeah.
And yeah, that's quite a challenge.
Yeah.
So it's not just about following these procedures, follow them to do substantive justice. Yeah.
Yes. Wow, that is very insightful.
One that we can say, I'll talk about what is captured under the law and what might actually be interpreted again under the law.
Yes.
When you fired me through WhatsApp, where is the notice? Where is proof of notice? Where is the proof of disciplinary? Those elements already as it is missing. You're also terminating me outside working hours. And again, the reason why we have so many employment cases and issues, employers still think you can handle employment relationship informally. That is such an informal way of dealing with the situation. You think you can just tell someone, I don't want to see you tomorrow. You think you can just tell someone over WhatsApp, you're fired. No. You cannot handle employment relationships informally. It works for you for as long as that employee does not report you in a court of law.
Yes.
But when you come into a court of law, we are looking at procedures as set out under the law.
Yes.
There needs to be notice, there needs to be disciplinary hearing or a procedure that has been undertaken if it's an issue of performance. Where will the KPIs been featured in that message? Where is the performance improvement plan? We will again go back to, have you met 1, 2, 3 and the disciplinary? 1, 2, 3 and a performance, and your WhatsApp message will not have met that, right?
Yes.
Again, it goes on again to be interpreted. Is WhatsApp an official tool of communication?
But we do use it.
You understand?
But we do use it to serve.
To this extent, yeah, we do use it to serve. It has been allowed to be used to serve, but I use serving notice. That's a different one. You do not report tomorrow. That's not notice.
That is termination.
That is termination without notice. So those are kind of the things. The other thing that can be argued, if WhatsApp is not a formal means of communication, what about the dignity of the employee? Because these days I've actually seen we go to court and employment law is actually evolving.
Yes, it is.
Part of the claims the employee will put, they could claim for even mental anguish. Depression, emotional anguish, and they get damages for that. So if they argued that you fired them in a way that does not dignify them, when the Constitution provides for right to dignity, then what? You understand?
Yes.
So you have to use a procedure that is recognized under law, but also meets basic minimum respect and dignity. Because again, with law, anything can be argued.
Anyhow,
and someone can set precedents, right?
Yes.
The first time, allow me to digress. The first time the courts tried to declare life imprisonment unconstitutional, the issue and the main argument, if you look at that judgment, though it was overturned, was dignity.
Yes.
The dignity of the person.
Yes.
Putting them in a way that they don't know when is the beginning and when is the end of their sentence.
Yes.
And they argued the issue of dignity.
Yes.
So someone can easily argue how you treated them while terminating them. And that is very important throughout the termination process.
Wow.
Yes.
That is very insightful. So to the employers, need to be...
But what the law has done is, because there are people who do not actually give their employees contracts despite being above 3 months.
Yes.
Of course, that is already unprocedural in itself. But that doesn't mean you're safe as an employer. What the evolution has done is, we've now used other means to interpret contract.
Okay.
And existence of an employment relationship. Because actually what a contract does is to prove existence of an employment relationship.
Yes.
So is it possible to prove existence of an employment relationship outside a contract? Yes.
Yes.
If this employee is able to show the duties you gave them, performance of duties, they can be able to show payment of wages, they'll be able to establish an employment
and also tools of trade.
And also tools of trade. Now even interestingly, some time back, the issue of WhatsApp groups came about.
Yes.
If an employee actually shows that in your company's WhatsApp group,
yes,
they have established the existence of a relationship. Employment relationship.
Yes.
Again, and there, once the employment relationship is established, even minus the contract, the court will assume the contract. And let me tell you the disadvantage of not giving your employees the contract. The burden of proving the terms will shift to you as the employer, and it will be very hard for you to prove under which terms the employee was working under. And what does that mean? The case of the employee and what they will allege will be more believable than your story as an employer.
Yes.
If they say no, my working hours were this, you don't have anything to show different from that. And if you're not able to what we call dispute their claim. It means it's the believable story.
Yes.
Remember, this is a civil kind of claim.
Yes.
And the burden is on a balance.
Yes.
What is the 50% chance that actually you were employed?
Yes.
That actually you worked 8 hours?
Yes.
You understand?
Yes.
So you not having a contract does not favor you as an employer. As long as this employee establishes relationship through WhatsApp, they'll show payment messages either through the bank, M-Pesa, tools of communication, tools of trade, then the courts can be able to assume employment relationship. Every other term will be for you to actually improve. And if you're not able to, the employee has the day at the court. Yeah.
Wow. You mentioned about the issue of casual laborers. This issue often comes up in Kenya a lot, the use of long-term casual workers. At what point does casual employment become problematic legally?
Well, I have experienced this kind of casual issues in the course of practice of employment. One thing that people need to know that under the employment law, actually casual employment can be automatically converted into a term, what we call a term contract.
Okay.
How so? If this casual employment consists of everyday work, and this everyday work together accumulates to more than 30 days, it's taken from casual labor to a term contract.
Wait, so you're saying if I have a casual employer, they work for me for, let's say, 2 months, continuously.
Yes.
This is being casual. They become permanent employees.
Yes, they become what they call term. It's called like a term contract.
Okay.
What it does is it will be transformed to look like, because casual laborers are never paid daily.
Yes.
Sometimes it's tabulated daily, but maybe
weekly.
So it will be taken as if you pay them monthly, and they have a term contract. So those are kind of the issues. The other thing that people do is, so for some casual laborers, they issue them contracts, correct? But then they issue them short-term contracts, 3 months, 6 months,
Yes.
6 months. But the total cumulative period of when this employee has worked is like 2 years.
What's the effect of that? Issuing employees with fixed-term contracts.
This is now being considered as unfair practices.
Oh, okay.
And the issue of casual laborers not being misused is that sometimes employers are trying to run away from statutory deductions, including NHIF, SSF. So instead of giving a proper contract or a monthly contract, one that will be termed monthly, because the monthly payment is where you are required to deduct taxes.
Yes.
And since you're running away from that, you try to transition it into a form of casual employment or short-term contracts for your own benefit.
Yes.
This has actually been termed to be unfair labor practice, and that means the court can actually decide to term this employment as if it was full-time employment for 2 years, and that this employee will have the same rights, and you will have the same obligations to that employee as if they were in a full-term contract of, for example, 2 years. Because when you come to things like compensation, the number of years you worked and the terms of your contract really determine, it actually influences the judges in terms of what type of compensation they give, because they have between 1 to 12 months compensation, right?
Yes.
And it's up to their discretion.
Yes.
But some of the things that determine whether they give you 2 months or they give you 12 months is the period you've worked. So they will look at this and they say, no, this is a fair labor practice, and cumulatively this employee has worked for you for 2 years, then they'll treat them as if they were in a 2-year contract, and then other dues will actually come up. What if they are entitled to now the issue of, for example, surveillance payment coming? Because with casual laborers, most of the times you find some are not paid NSSF, NHIF, because one, you are trying to run away from it.
Yes.
And then now what the court will do, since you didn't pay them, is to grant them a surveillance pay.
Yes.
So that actually happens many times. So people need to avoid that type of practice. It's actually not condoned in law.
Yes.
And in the event you end up in the corridors of justice and a dispute, that could really turn against you as an employer. And once the court has a feeling that you're a biased employer, or that you're actually doing things that they consider unfair labor practices, then your case already is imbalance as an employer. So those are part of the things that we need to avoid.
More so because the courts usually they hold the employers on a very high Yes.
regard. Yeah.
Yes. You mentioned about toxic work environments, and we are seeing recently we are seeing increased discussions around toxic work places and employees' well-being. Is workplace culture now becoming a legal issue? Do you think that?
There's an issue of constructive dismissal that is coming up,
Yes.
which is related to the work environment.
Yes. Yes.
So to an extent that you have not really fired this employee, but the conditions you have made them work under are so intolerable that the employee decides to quit.
Okay.
You understand? So you have not fired them,
Yes.
but you probably frustrated them enough want to leave employment. So part of the issues that could be, of course, toxic is very broad, and that's open to court's interpretation. Not every action or every issue between an employer and an employee amounts to toxic.
Yes.
That is a very broad term that has not been defined under employment law, so it is subject to proof.
Yeah, case by case basis.
Yeah, case by case basis. But there are things that, can lead to an environment being termed as toxic under employment law. So denying employees the rights that they're entitled to under law, including leave. There are employers that make taking leave impossible, even though your contract guarantees that leave, or even though the law provides for leave. There are also work environments where when you raise issues about a supervisor, an issue, you end up getting backlash.
Yes.
Because employees have a right to complain.
Yes, they do.
And they have a right to even report certain cases. For example, sexual harassment.
Yes.
There's a whole policy about sexual harassment that actually employers need to have in their companies. And I don't know if many employers know that once you have a certain number of employees, you're supposed to actually post these different type of policies, correct?
Yes.
So if you complain about sexual harassment, and maybe the person is your senior or your supervisor, and that results into a backlash kind of treatment. Maybe you now don't get certain privileges you get, or you're now denied work, and maybe it's an environment where the more you work, you're entitled to bonus, or even your bonus is being deducted.
Yes.
Such kind of things create a harsh working environment.
Wow.
And also arbitrary deductions. Employers are not actually allowed to make arbitrary deductions without the consent of the employee.
So if I come in late to work, is my employer not entitled to deduct from my salary?
You are actually not allowed to deduct arbitrarily and without informing the employee. The
What
employee
happens?
has to be informed, and a consent or an agreement has to be reached so that you can be able to deduct. So you are allowed in some circumstances to deduct an employee's salary. But if you check the law, the employee needs to be informed, and some level of consensus or consent in some cases needs to be reached. So in the event you continuously deduct someone's salary, today you see they are late, tomorrow you see something else, or even poor performance,
Yes.
and the employee goes to court, your reasons will not stand. Remember when we started this, we said you have to prove your reasons are valid.
Yes.
They met the minimum criteria under that reason,
Yes.
and the procedure was followed.
Yes.
So in this particular case, you'll not have followed the procedures.
Yes.
The employee is not informed of why, and again, being late, the solution or the repercussions for being late is not salary reduction. Like we said, being late or not coming to work is gross misconduct.
Yes.
And the law provides for what you do in cases of gross
Gross
misconduct.
misconduct.
And it's among the few areas where you're allowed to terminate without notice. But it requires a disciplinary hearing.
Process. Yes.
So if you've not done a disciplinary hearing and the whole procedure has been met and you're not satisfied so that you summarily dismiss, you've not met the threshold of that procedure. So in such kind of circumstances, your money is deducted, you cannot take your leave, you have a harsh work environment just because you reported a certain issue. Cumulatively, an employee might be able to prove that created a hostile. In fact, the one is hostile.
Yes.
Environment.
Yes.
And if the court agrees with them, again, we are dealing with a balance of
Probabilities.
If there is a 50-50% chance, then actually, when I look at these issues, you did create a hostile environment that led to this employee quitting. It will be termed as constructive dismissal, and the employee will still be awarded for unfair
Termination. Must the employee quit? for it to be termed as constructive dismissal?
In most cases that we have seen in practice, the employee decides to quit, but there are times where what we call abscondment, an employee disappears from work. And one thing I want to tell employers, which is one of the mistakes they do, is like I told you, employers really handle employment relationship casually and informally.
Yes.
So thinking as an employer, this is what you're thinking.
Exactly.
But can I tell you something interesting under the law?
Yes.
The law actually requires you to look for that employee.
Wow.
You have to attempt to look for that employee, attempt to look for them either to bring them back to work or to give them notice that if you don't come back to work, we'll institute a procedure to terminate you.
But how will the courts know that I have looked for this person? I have called this person. We have spoken on the phone.
Again, records.
Wow.
If you are trying to look for an employee, you have to document the procedures of your tenants. If you try to send them emails through their already established emails, you send them emails, you left them messages in their already established. And one of the things that we even do, maybe as lawyers, I can give them that example because maybe many people might not know.
Yes.
You've said we are allowed to serve via WhatsApp.
Yes.
It's true. But part of the things that we do is to actually attach an M-Pesa message that confirms the name corresponds to the number.
Yeah. Yes.
So it's not, you have to show that this number you've used actually belongs to that employee and that employee has been using it. This email you've used actually belongs to the employee. This post you've used is their last registered post if you're still using post. If you've sent someone maybe to their places of residence, if it's a casual employee that you know where they are, you must try to attempt to reach them and document that attempt. And then tell them, come back to work, or if you don't come back to work, we'll institute these procedures even in your absence and then we'll terminate you. So it's not enough to say, oh, my employee left me. What will I have done? I hired someone else. No. The law actually requires you to attempt to find them. And I know that's quite interesting. It baffles me. But like we say, law is the law.
Yeah.
Yes.
The law is very clear.